And again, Mr. Vila, thank you for the amended information. It looks
Yes,
all
Your
clean. It looks clean. I like it.
I
We'll
like
go on the
having good
record. Go ahead.
documentation.
What?
I just wanted to say I like having clean
I
documentation.
love clean paper trail. We'll go on the record in the matter 25 CF 145, State of Wisconsin versus Jacqueline Shabayish. The state appears through Assistant District Attorney Jose Vila in person. Ms. Shabayish appears in person with her counsel, Joel Feliski. We're set today in this matter for a plea and sentencing hearing. Mr. Feliski, the parties have reached an agreement. Can you please recite the agreement for the record?
Yes, Your Honor. Thank you. Ms. Shabayish has agreed to plead to count 3 amended in the complaint to possession of methamphetamine, with count 1 being dismissed outright and count 2 being dismissed and read in. The parties are making a joint recommendation here for a deferred judgment of conviction agreement to last approximately 12 months. I have that document with me along with a completed plea questionnaire form. May I approach?
You may. Thank you. Ms. Shabayish, I have in front of me 2 documents. One, a deferred judgment of conviction. One is a plea questionnaire waiver of rights form. Do you recognize these documents?
Yes,
Are these the documents that your attorney just went over with you?
yes,
Did he go over them thoroughly with you?
yes,
Essentially word for word?
yes,
And did you understand everything on the documents?
yes,
Is this your signature on both of the documents?
yes,
You are pleading guilty to 1 count of possession of methamphetamine, a class 8 or a class I felony. Is that correct?
yes,
Okay. Okay, so, sorry, I had a message and I was just trying to respond to it. So you sign these documents, you're pleading guilty to a felony. You are 44 years old,
yes,
12 years of schooling. You can read, write, you understand the English language, all correct.
yes,
And you are receiving treatment for mental illness or disorder,
I am,
substance abuse treatment?
yes, yes.
Okay.
Yep,
People count that as that, okay? So it's not like they're saying that you're suffering from depression or anxiety or you're getting, or schizophrenia or
Yeah.
anything like that, okay? No alcohol, drugs, or medications?
no,
Because you're charged with crimes, you are entitled to constitutional rights, and each of the rights is listed on both documents on the first page. Do you understand those rights completely?
yes,
Your attorney thoroughly went over those rights with you.
yes,
Do you need me to go over those rights with you in any more detail?
no,
Do you understand by pleading guilty, you're waiving and giving up those rights?
yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
Do you understand that you're pleading guilty to a felony? If the court follows the deferred judgment of conviction, that kind of hangs out over your head. But if I do, and let's say that you do something that's not in compliance with that deferred judgment of conviction and it's revoked and the state asked me to enter judgment and to sentence you, at that time, do you understand that you will no longer be able to use or possess a firearm for life?
yes,
No longer able to vote in any election until your civil rights are
Yes.
restored. Do you understand here that the state would have to prove on or around September 23rd, 2025, you possessed the substance was a controlled substance, methamphetamine, and that you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what the state would have to prove?
yes,
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 3.5 years or both?
yes,
You understand that there is this deferred judgment of conviction and it has certain requirements that you must follow for a particular period of time. And here it's 12 months. Do you understand that?
yes,
Do you understand that if you do not follow these to the letter, that the state could ask the court to enter that judgment and sentence you?
yes,
And part of that is that you must do an AODA assessment and follow through, and you must provide the notice within 180 days of signing this agreement.
yes,
Do you also understand that within 60 days, you must pay $150 to the district attorney's office?
yes,
That is the number one reason I see the state asking to enter judgment. The second is providing that notice of AODA, okay?
Yes,
Now, do you understand? I'm not bound to follow that agreement. That if I thought that the facts here warranted it, I could say, you know what? I'm not accepting that deferred judgment of conviction. Do you understand that?
yes,
Do you still wish to proceed and enter a guilty plea?
yes,
Did you go over the criminal complaint with your attorney?
yes,
In particular, there is that section called the probable cause section where it basically says what happened and why you were charged with the crimes.
yes,
For the most part, are those facts accurate?
yes,
All right. Mr. Felisky, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Are you pleading guilty to this charge because you are guilty of this charge?
yes,
Okay. Now, has your attorney represented you competently?
yes,
Has he done a good job?
yes,
Has he looked at this matter thoroughly?
yes,
Has he discussed the facts and the evidence with you?
yes,
Has he discussed any potential defense or a lack of defense with you?
yes,
Are you satisfied with his services?
yes,
Any questions for the court or for your attorney before I proceed?
no,
As to count one, or actually count three, possession of methamphetamine, how do you wish to plead?
guilty,
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of possession of methamphetamine. As to whether to enter judgment, Mr. Vila.
Thank you, Your Honor. I believe the crux of this case is that this is a personal drug abuse issue. After receiving input from law enforcement, I believe the joint recommendation here is appropriate in this matter. Ms. Chabayes is here taking responsibility for her actions. As such, I think she also realizes that she needs treatment to kind of get better and make sure she doesn't appear in front of this court again in this manner. I think the terms of the deferred sets her up for success in that matter. She has a chance to earn her way out of a conviction, specifically a felony conviction here. I don't believe she has any convictions of a felony nature on her record to date at this point. So this should properly incentivize her to get treatment, stay clean, and if not, that threat of the felony conviction will hang in the balance. Yeah, the main goal here should be to reduce the chance of recidivism in the future. As such, I would ask the court to adopt. Thank you.
Thank you. Mr. Felisky.
Thank you, Your Honor. I concur with the remarks made by the state. I think that the resolution here is appropriate, given the nature of the offense here. This was a personal use amount alleged here, and Ms. Chabayes has actually taken the initiative. In fact, before this matter was renegotiated for a DJOC, she actually already has enrolled and has been participating in AODA assessment and subsequent follow through. I believe, and again, agree with the state here that the terms of this agreement will keep Ms. Chabayes accountable, will prevent future offenses from occurring, and will allow her to ultimately address the underlying issue that led to this charge to begin with. Your Honor, I overall think that this is an appropriate agreement, and I would ask the court to follow it. Thank you.
Thank you. Ms. Chabayes, anything you want to add or you want to tell me?
I am an AOD. I have been for the last since September. I got a job in December. I'm working full time at Little Turtle Hurdle.
Oh, nice.
Yeah, and I just got my daughter back. So things are going good.
It sounds like things are going amazing.
Yes.
And you are taking control of your life
Mhm.
and you are putting yourself on a better path.
Yes.
And that you should be proud of yourself and what you are doing. How many days have you been sober?
It's been September 22nd.
So, well, actually, was it the 22nd or was it the day of the incident? Because that was
The day of the
23rd.
incident.
So the
Yeah.
23rd. So
Yeah.
you're close. I just want to make sure that you know. It's very important that you know that date. I mean, you don't have to exactly know that date, but because every day that you remain sober and you continue to work on you and your substance abuse issues, every single day matters.
Yes.
And it's every single day you should be proud of yourself and what you are doing.
I am.
And I'm so glad to hear that. I think this agreement is appropriate. This isn't a serious matter of a dealing or intent to deal matter. This is a self-use case. And who you were hurting was yourself and your daughter.
Yes.
your family, your friends. So I believe it's appropriate. So I am going to accept the DJOC. And what I'm also going to do, you have $500 posted. I do have to keep that until the DJOC runs.
Okay.
However, I'm willing to release $150 from that to the district attorney's office. So you don't have to come up with another $150, okay?
Okay.
And then that is done, check off your list. Make sure you do the AODA stuff and you
Yes.
get all of the notice and all of the updates to the district attorney, okay?
Yes.
All right, so I will be directing the clerk to transfer $150 to the state, and then you are good to go. All
Thank
right?
you, Your Honor.
I'm so proud of you.
Thank you.
All right, thank you. We are adjourned. Right, we will go on the record in the matter 25 CF 170, State of Wisconsin versus Wesley Alwyn. I do not have Mr. Alwyn. I know I gave him permission and to appear by video conferencing. I do not have him located here waiting to come in, but I do have Joel Feliski, his attorney. I have the state through Assistant District Attorney Jose Vila, and I do have Officer Deputy Schaefer, who is appearing, who is going to be providing testimony here today. It's 11:18. This was scheduled for 11:15. Mr. Feliski.
Thank you, Your Honor. I contacted the St. Croix County Jail this morning to call them specifically to confirm that they have the information for Zoom. They advised that they did and that Mr. Alwyn would be appearing at the time scheduled. I have no answer for why he is not appearing as scheduled. I stand mute.
Do you see why I don't like appearances from jails?
Yes, Your Honor.
And I'm not blaming, I'm not saying you or anything, but this is a privilege to be able to appear by Zoom. And it does put a lot of extra work on our jail staff to have to facilitate these things, because really that's not their job to facilitate court hearings. Their job is to take care of the inmates, to make sure that the jails are running and to do all of those functions. And since the wonderful invention of Zoom court, everybody has extra things that they have to do. They're not getting paid more. They're not getting any other benefits. They just have more work and more things to do. So here's the deal. I'm sorry. I'm not allowing Zoom appearance by St. Croix County anymore for Mr. Alwyn. So the court is going to issue a warrant, body only. We'll have him.
This right here is why judges hate jail Zoom appearances. When inmates don't appear on time, the court doesn't blame technology. It treats it as a privilege being abused. And the result? A body-only warrant. No bond, no shortcuts. Court efficiency isn't optional. It's enforced.
When we get them. All right. Thank you. We are adjourned.
Thank you, Your Honor.
Record in the matters 25 CF 89, 26 CF 09, State of Wisconsin versus Timothy Ainley. The state appears through Assistant District Attorney Jose Vila in person. Mr. Ainley appears in person with counsel Zachary Fisher by video conferencing. We also have Kate Murtaugh, who has been appointed on a limited basis for the minor child in this case as guardian ad litem. We are set here. We are in victims' rights compliance. We are set here for two things, a plea and sentencing and an arraignment. Before I begin, Mr. Fisher, can you please update the court?
Yes, Your Honor. So the parties are not going to be proceeding with a plea and sentencing on the underlying file. We are going to ask the court to have these files tracked together. I do have a global offer from Attorney Vila, and I have discussed that with my client. I have also received discovery on the new file, and we'll send that to Mr. Ainley shortly. I would just ask for a status 60 days out, and we could proceed with the arraignment today so that the parties can consider a global resolution and I can review discovery on this file.
All right, thank you. Can I please get the offer that's been extended?
Yes, Your Honor. The offer is one of two things. It is either a plea, the pleas are the same. It is one of two joint recommendations or a contested argument. It would be a plea as of right now to misdemeanor battery in 25 CF 89 and a plea to felony abuse of a child in 20 CF 609 and felon in possession of a firearm. there would be either a joint recommendation for 2 years of initial confinement and 3 years of extended supervision, or the parties would be jointly requesting a PSI, and I would be free to argue for any sentence.
Okay, all right. Okay, and Mr. Ainley, you understand the offer as it's been stated?
I do.
Okay, all right. So right now, with regards to the 26th case, Mr. Fisher, you went over the criminal information with Mr. Ainley?
Yes, Your Honor, we have received a copy of the information. We would waive further reading. We would waive speedy trial, enter not guilty pleas at this time, and ask to set for a status conference.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. March 30th at 11, you're coming back here, Mr. Fisher, or at least I have you for statuses. March 30th at 11.
Yes, Your Honor.
All right. Anything else we need to address here today?
Not from my perspective, Your Honor.
No, Your Honor, thank you.
Okay, thank you. And Mr. Fisher, so we are adjourned as to that matter. I'm just letting you know, since you are his criminal attorney, this doesn't affect you or relate to your representation, but I do have an issue as it relates to family. So I just wanted to let you know that I will be having a brief, I don't know if I'll even have a hearing right now as it relates to the family. So I was just letting you know.
Thank you, Your Honor, and I will have Mr. Ainley discuss that with me if he has any questions about it.
Okay, thank you. What? I'm sorry, my ears clogged right now for some reason. Oh, Mr. Fisher's gone. Oh, you need to come up here and sign your bond. For some reason, it didn't get signed. Thank you.
Judge, did you want me to stay on for a minute?
Sorry, Miss Murta, I didn't even address it because I didn't see your face on the Zoom. So
Oh.
when I don't see the face, it's hard for me. I forget sometimes.
That's
So
okay.
what I meant on a limited basis is you don't need to go to be involved in all of the negotiations. You can,
Oh, yeah.
yeah.
That's your copy, yeah.
I'm
And then do you
sure
want me
you've
to
been a
just
part of
mail you
one
a
before. You
copy
said
of
you've been
this, or
appointed
do you-
before as
has
guardian ad
this
litem and a
copy
criminal.
machine
So it's not in the
Yeah.
whole
Give you one
total.
out
You
there
do all of
if
the
you want.
things.
Correct.
I can give you a
Yes, so
copy
I just
out by
wanted
the clerk's
you to,
office, or I can mail this to you.
just wanted to be on the
Yeah.
same page.
Yeah, I envision it's more
This has left.
just support for Noel.
Okay,
So-
yes, and I appreciate that and
Okay.
thank you.
Yeah.
So you are free to leave. Can you run, go get Ms.
Thank you,
Hess?
Judge. And you don't want me on for the family?
This wouldn't relate to the children. It's just a
Okay.
property issue.
Thank you.
Thank you.
Judge Mogen. May I request that her boyfriend step out? He has nothing to do with my family matters.
No, it's an open hearing, open court.
All right.
So Ms. Hess, if you can please come forward and have a seat. This isn't a formal hearing. I don't know if we're getting the clerk, but. So this isn't a formal hearing. This is just because I don't think I have a clerk and we don't have it on, but there is an issue as it relates to the quitclaim deed and the house, Ms. Hess, and signing that. So I did do an order that Mr. Ainley would have to provide at least a copy of what the quitclaim deed is. But I do have to say it is incorrect because it has her former name. So it would also, it says Ainley, it would have to be Ainley, also known as Hess.
I don't understand. This is the one I signed. Oh, on the one that she's got to sign?
Yes.
Okay. you see.
Well, and on the one that you signed.
Oh, okay.
Yeah.
All right. I see. Okay, I can get a different copy of this from my attorney.
So what I'm gonna need to do is set this matter for a hearing. And so do you understand what it is,
Yes.
just with the quitclaim deed? And if there are any other issues as it relates to the house, but I have no other, but I have a motion filed by Mr. Ainley on some matters. So did you get a copy of that? No. Did you serve her?
They couldn't find her.
Okay, well then I can't even hold a hearing on that, but you're out of custody now. So You are seeing Commissioner Krupa, I believe, in a couple weeks.
Yes, ma'am, on the
So
12th,
this
I believe.
may be an issue for Commissioner Krupa because if you have a correct deed, then he may go ahead and have her sign it.
Yes, ma'am.
So, or whatever, and I don't even know what's going on with Commissioner. I haven't looked. He has his own stuff he handles, and then if he can't handle it or it needs to be a judge only, then it gets
Yes,
sent
ma'am.
to me, okay?
Okay.
So I'm not gonna set a hearing, but I do have the copy, and again, your legal name is not Ainley anymore, correct?
No, it's not.
You changed it over and have your driver's license and all of those things?
Yes, Your Honor.
All right, so it has to be changed.
Has to be a Hess, Rachel Ainley Hess, or what?
Yeah, also known as, or formerly known as, or all of those things.
Yes, ma'am.
So if it's done by Mr. Lean, talk to Mr. Lean about that, okay?
Okay.
All right. We will go on the record in the matters 25 CF 112, 25 CF 131, State of Wisconsin versus Joshua Mersha. The state appears through Assistant District Attorney Jose Vila in person. Ms. Hanu appears by video conferencing with approval of the court. Mr. Mersha appears by video in custody in Burnett County Jail. We're set today in this matter on a bail bond modification request. I have received the request and I've read it, but Ms. Hanu, anything else you would like to state on the record?
Nothing further from my motion, Your Honor. I do know Mr. Mersha did wish to address the court.
All right. And Mr. Vila, you were able to review that request?
Yes, Your Honor.
Okay, Mr. Mersha, what would you like the court to be aware of?
First of all, I would just like to thank you as an individual judge and the court as a whole for affording me the latitude to move the original or reschedule the original court date due to a family medical emergency, as was stated. So thank you on behalf of my family and myself. We appreciate that. And despite the technical difficulties that I had resulting in the failure to appear, that was not my intention, and that was not a disregard, intentional disregard to the court. So retrospectively, in light of the hurdles and technology and my lack of preparedness, I am definitely 100% accountable for not having those things in place before the allotted and scheduled time for the hearing. And so in my days in custody that I've had to reflect upon things that occurred that prevented me from connecting with that hearing, I have come up with several things to implement as corrective action in the future to prevent same scenario. And I would first allot adequate time before the hearing to address any type of technical issues and connect from my computer, not rely on my phone, and connect on my computer through a LAN Wi-Fi connection, not my intermittent hotspot connection, and using my phone would be my corrective action, along with adequate time before the scheduled hearing. And so that's the plan that I've been able to develop since I've been in custody on 1/1 of 26 till today's date. And that's what I plan to implement in the future as corrective action. So again, thank you on behalf of my family and myself, and my apologies to the court for the unintentional disregard. I'm 100% accountable for my actions, and yeah, that's all I have to say. Thank you for allowing me the time to address the court.
Mr. Mersha, if every defendant that requested to appear by Zoom, which is a privilege, it is not a right. I do not have to grant that at all. If every defendant that fails to appear.
This exchange is rare, routine, and powerful. Instead of excuses, the defendant owns the failure, explains corrective steps, and accepts responsibility. Judges aren't looking for perfection, they're looking for insight. This is a textbook example of how accountability can directly influence outcomes like bond modification.
Thought about that failed appearance, whether it be because of your issues, technical difficulties, or because they're late, or all because all of these other things, if they were to sit down and actually reflect and think about what it means to have that privilege to appear by video conferencing, I would be so happy. You actually took the time to reflect on the importance of ensuring that your media, your technology worked and worked properly. Like, you understand that importance now. You understand that it is on your shoulders if you are late for Zoom, if the technology isn't working, all of those things, which every defendant that is given that privilege to appear by Zoom should. And if they don't have the ability, if they have spotty Wi-Fi or all of those other things, then they should ensure that they're seated in that chair on the table right in front of me. I appreciate your reflection, your insight, and your words, Mr. Mersha. Thank you. Mr. Vila.
Thank you, Your Honor. You're welcome.
Thank you, Your Honor. Thank you, Your Honor. State does not oppose the bond modification. It's a minimal amount of money that they're asking for the reduction, and given that there seems to be underlying medical issues that Mr. Mersha needs to address, which appear to be serious in nature, I think it's appropriate.
The court will grant the request. I will reinstate the bond at $2,500, same conditions. Mr. Mersha, again, thank you for that reflection.
Thank you for allowing me the time to address the court. Appreciate that.
All right.
Thank you.
And now
And
we
again,
need,
I'd
we're,
like to
go
formally
ahead.
apologize and respect you as an individual for making the call. And I'd also, ultimately it was your decision, Judge, to move the original date. You afforded me and my family that latitude. It was a very stressful day, and I was in no condition to appear in front of much of anybody, let alone a formal setting such as this, albeit remotely. And I'd like to also extend our appreciation again on behalf of my family and myself to the DA or opposing counsel for choosing to not contest that. So thank you as well. And
Thank you.
Appreciate it.
We currently have another status scheduled for February 19th at 10:30. That's not too far off, and we can reset it, Ms. Hanu. Is there an update you can provide me? Have you had any further discussions with the DA or ADA?
Yes, Your Honor. Last time we spoke about what was going on, Mr. Mersha is engaged in IDIP. All we have left is the MAD impact panel. I have not thus far been able to find an affordable way to do that. And obviously, Mr. Mersha has been in custody.
An affordable way? What do you mean by that?
Mr. Mersha is just currently unable to afford to pay for a MAD impact panel. I was looking into possibly.
How much?
It's $60, Your Honor.
Well,
right, Josh?
I have bail. I'm not opposed to ensuring that he can do what he needs to do to complete what he needs to complete. And if it's a minimal $60, I'm not opposed to releasing that.
Josh, how does that sound?
I guess Yeah, I would appreciate that. I think it's just been difficult because I haven't been working and as a result of my actions and poor judgment, I no longer have self-transportation to rely upon, and that's been a hurdle, and thus subsequently a financial hurdle as well. So things have just piled up quickly. It seems like a very kind of minuscule amount, but yeah, things have been difficult for me. So I
Mr.
would
Mersha.
appreciate that. Thank you.
$60. It may seem like a small amount. It's not. It's not. It's still cash. And when you're not working and your family was relying on you to provide the income and to take care of them, it is a lot to have to come up with. The $2,500 cash I have right now was a lot to come up with. And I'm glad that you're not in a position, or you're not going to allow yourself to be in a position where you will forfeit that. So, Ms. Hanu, all I need from you is for you to file the information of where we will send that money to, and the exact amount that we need to send, so that we can take care of that. And if he has any other charge related expenses that would need to be paid, other than fines and fees that we'll deal with later. If he has any expenses for the IDIP or anything of that nature, let me know that too.
Thank you, Your Honor. I will get on that.
All
Thank
right.
you. Appreciate
Thank you. All right, thank you. Do we want to move the February 19th date, Ms. Hanu?
Josh, does February 19th still work for you?
I think we should move it. If he's gonna get out, he's gonna
It's
do
kind
his
of
thing.
close, and I would need to have access to my ledger to, within my phone, and to make a definitive response or answer to that.
I'm fine with moving it, Your Honor.
I think we should move it. Ms. Hanu. Let's move it to March 30th at 10:45. March 30th, 10:45. You're coming back. You have a hearing on that date and time anyway. So you'll just give me an update. I'll have all of that information of any fees he needs to pay, and you'll get my approval, and we'll take care of that out of his bail bond that he's posted. And then Ms. Hanu, also, since it's far out to have this next status, please keep the court updated on his progress of his completion of all of this, and perhaps we can get a different date and time to fully take care of the matter.
Absolutely, Your Honor. Thank you.
All
I have
right,
a
thank
question,
you.
Your Honor, before we wrap
Yes.
up, if I may.
You may.
Pardon the interjection. If I were able to source a location or a nonprofit entity to invest in our requirement for the hours requirement for community service, I believe it is, that's part of the IDIP program. May I continue with those hours over the pre-conviction requirement for IDIP?
Yes, definitely.
I believe it's
definitely.
8 hours, but if that's the ultimate resolution to the case, if I was to invest into hours over that, would that be approved and accepted by the court?
Yes, it would. And for some reason, I don't have what the BAC was.
I can pull it up, Your Honor.
.367.
I believe when I spoke with Tessa
Wowza.
Anderson, I think her name is, the number 250 hours comes back to mind.
Yes, 250 hours. Take care of that as quickly as you practically can. And Mr. Mersha, I wouldn't be opposed to your attorney filing a motion when this does resolve to do additional community service, to be able to have the court waive as much of the fees that the court can.
Okay,
All right?
thank you, Your Honor. Appreciate the
Anything-
court's time.
Anything further?
No, Your Honor.
Pie.
Yes, because it happened the day of. Okay. So we would need
Oh,
yesterday, but yes, we would, because it happened the day of.
okay.
But I mean, if it's cleaner for you, but because it would say all of three of the charges in CCAP, we want them to say, have all the charges, because again, it's the day of, and then it would be
Q&A?
prosecutor's motion, and then not.
Oh,
guilty
with like the
for jury.
witnesses?
Yeah,
Oh,
I put that in there for right now because I have.
Why?
Because sometimes it goes really fast.
Mhm.
Especially if I need to close it out. But yeah, the amended information changes. all of
Oh.
the stuff. So, remove the disposition.
I never got too fast or unclear with open or closing. Okay.
Okay, I guess I don't understand. Sorry, we'll be with you in 1 second. I'm just trying to logistically figure out our system.
So
That's good to hear.
if I dispose of it, if I'm guilty of jury trial.
I do comport myself a little differently at jury trials.
Oh, yeah, so it's fine with me, whatever. If he is gonna find me, that's good and that's fine, because I didn't know ahead of time that it was going to be not pursued at the trial. You didn't know that either.
Yeah, so then, because it would still have to do. Oh,
Yes, do that. All right. Can you both hear me?
Yes, I can hear you.
All right, we will go on the record in the matter 24 CF 137, State of Wisconsin versus Eliza Mitchell. The state appears through District Attorney Kevin Schmidt in person. We do have Ms. Mitchell appearing by video conferencing in custody in Burnett County Jail. We have Jacob Gondik appearing by video conferencing with approval of the court. We're set today in this matter based upon a motion and or I don't know if it's, I don't believe Mr. Gondik filed a motion, but Ms. Mitchell filed a motion and had a lot of individuals file letters, character references on her behalf, asking to have the court allow her to be on electronic monitor with GPS and alcohol testing 24/7. So that's why we're here today. Anything you want to add with regards to that request, Mr. Gondik?
Your Honor, I would obviously, my client kind of took the reins on this and obviously filed the information with the court. I mean, I think she's certainly earned this opportunity based off, it looks like she's doing a lot of good things in the Burnett County Jail in her first approximately getting towards that 180-day mark. It looks like she would be eligible, provided this court grants her the opportunity for this GPS monitor on February 10th. I've had some coordinating with the individuals that run the monitor department through Burnett County. It sounds like everything would be a go, provided obviously this honorable court grants that request. So based off everything that Ms. Mitchell has submitted, I think she's earned the opportunity, but I'll certainly let her speak if she wishes and defer to the court.
Oh, all right, Ms. Mitchell, I will allow you to make a statement here today for you to let me know what you want me to know and why you are seeking the monitor and why you believe the court should grant that.
I first wanted to start off saying like how proud I am of what I've figured out about myself. I've learned a lot about myself being in here, and then I've mentally grown just so much, and I'm ready to be home with my son. And my plan is to meet with my PO and schedule my speech that I also wrote about in my letter to you. And I have my work set up for the 16th at 9 a.m. I feel like I've earned it because, you know, I've completely changed my life around, and I continue to keep that going. And I just wanted you to know that I've been doing my best into changing everything and just staying consistent in a good and healthy lifestyle. And I'm ready to continue that and be a mother to my son again and be able to raise him in a good and healthy way.
Okay, thank you.
Yes.
Mr. Schmidt.
The victim's input in this is, all he said was he believes Mitchell should sit her time. I don't take a position because if you recall, I was capped at PSI and PSI came with a weird recommendation about conditional jail and when it should be served. I do note the judgment of conviction says first 6 months in county jail, second 6 months if court approved ECM. So I do think her request is consistent with what's already on the JOC. That's all.
All right, thank you. And the victim did not want to do any statement or anything other than what you have said here today?
He explicitly said he wasn't going to be in court and didn't want to speak.
Okay, all right. How long has she been in custody?
The sentencing was July.
Oh, Mr. Schmidt.
The sentencing was July 15th. Since it was conditional jail, we'd count from there.
Okay.
So she's either at or extremely close to the 6 months.
Okay. All
Wait,
right.
no, she's beyond it. She's at like 8.
Well, she shouldn't be if there was only 6 months conditional jail. July, August, September, October, November, December, January, February. She should be. Yeah, that's weird.
What the JOC says is 12 months of conditional jail, first 6 months in custody, second 6 months if approved to the monitor.
Yes,
You're-
okay. So that's where we are. Mr. Gondik.
Yeah, if I could speak to that, just as far as the, so we got that right. DA Schmitz is correct as far as the date of sentencing, but she had 30 days to report. So she went in August 15th. So she's coming up in the middle of February. So I think the 180-day mark is either February 9th or February 10th, but I know based off the jail's count, I think February 10th is the day, provided this honorable court approves it, she would be able to get released. So that's how there's a month difference there.
Okay, and thank you. I appreciate that. And Ms. Mitchell, you had said something in one of the letters that that you have a job or something's happening in February. Can you update me? Tell me about that.
Oh yeah, so my first letter, I said it was supposed to be the 11th or 12th, but I got verification from my boss that my orientation is on the 16th at 9 a.m. And then I would start work either that weekend or around that time.
Okay.
And my boss is able to confirm my job if needed.
Okay. I would like to see that. All right.
Okay. I can
So
have
I would-
her, do you know where she could send it, or does she have to call up here?
Well, it can come through Mr. Gondik, so make sure
Okay.
she can get it to Mr. Gondik and he can e-file anything. And then when I have that information, and I want to make sure that I have information where you're going to reside, and those things, and it's very important that you understand that if the court were to grant this, this is house arrest. You would only be able to go out of your home for certain things, and that would be for work-related things, for substance abuse-related things, for doctor's appointments, anything else, and that means anything else, even a funeral of somebody very close to you passing away, you must get my permission to be able to attend, okay?
Yes, Your Honor.
If you
Does that
don't,
include my son's doctor's appointments too?
well, I would have to have information about when they are, how often they are, etc. Okay? So
Okay.
make sure that I get that information and you can write that to me, or you can give that to Mr. Gondik, okay?
Okay,
All right, so get me that information and I will let you know my decision after I have that information, okay?
okay. Thank you,
Eliza,
Your Honor.
Eliza, call my office the moment we get off this Zoom, once you get an opportunity so we can discuss that letter from your boss.
Okay. Sounds good, thank you.
All right, okay, thank you.
Thank
We
you, Your
are
Honor.
adjourned.